All right. I call to order special meeting for the city of Whittier, Alaska, September 14th, 2023. The time is now 6:05 p.m. Please rise for the Pledge of Allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Roll call, please.
Here.
Wagner,
Here.
Blair,
Here.
Arneson,
Yes.
Denmark,
Here.
Pencush, absent. Mayor Dickinson,
Here.
you have a quorum.
Citizen comments on any agenda item not scheduled for public hearing. Those who have signed in will be given the first opportunity to speak on any agenda item except those scheduled for public hearing. Time is limited to 2 minutes per speaker and 30 minutes total time for this agenda item. And I'll allow a little extra time if somebody needs it, as long as they're making their point. Nobody signed in? All right. Anybody in the audience here want to say anything? Seeing none. Next item was the approval of the special meeting agenda. I believe that this ordinance being introduced for public hearing, that could be just added to as a
Consent?
consent item.
Yes, Mayor, you're more than able and welcome to add it as a consent item.
Okay. Does anybody want to add it as a consent item?
The first reading of this ordinance?
This is
Just
just
the
for introduction. It's not a first reading.
You'll,
What's the difference?
so the introduction is just the title. And then if you want to discuss it, you can. And then at the next meeting, it would be public hearing and basically the first ability for the public to come in and talk about it.
Okay, so, and then there's an executive session scheduled for which the context of this ordinance is likely to be discussed.
Yes.
I have no problem on the consent.
I'd like to discuss it.
Okay. Okay, then can I get an approval for tonight's agenda?
Motion?
Sorry, a motion. Thank you.
So moved.
Second.
All right.
Motion and second, voting on the approval of the special meeting agenda. Denmark,
Yes.
Wagner,
Yes.
Blair,
Yes.
Shen,
Yes.
Arneson,
Yes.
Mayor Dickinson.
Yes.
Your agenda is passed and approved.
Okay. First item.
You want me to read it?
Yes, please.
Next item on the agenda is for public hearing for introduction. It is ordinance 2023-004, an ordinance of the City Council of Whittier repealing Whittier Municipal Code 2.08.350, improper use or disclosure of information, and amending Whittier Municipal Code 2.10.130, prohibited acts, to incorporate the prohibitions of Whittier Municipal Code 2.08.350 and add appropriations against disseminating false information or using title or position to duly influence others into the Whittier Code of Ethics, and amending Whittier Municipal Code sections 2.10.020, 2.10.048, and 2.10.070 for clarity. I need a motion and a second.
I'll make that motion.
I'll make a motion. Second.
Motion made by Wagner, seconded by Blair. Now it is open for administration discussion, and we have Attorney Holly Wells on the line.
Jack, you could do, is this the appropriate time to
Yes, Holly, go
sort
ahead.
of weigh in?
Yeah, yes, Holly, go ahead.
Yes, Holly,
Okay.
we're
Okay.
waiting for you to give an update about this ordinance.
Okay, so this ordinance really derived from several reports we had received that a specific council member had been claiming that there was.
We got an echo.
Oh, let me see if I,
We don't on
is
our
that
end.
better? Let's go.
Just give me the goddamn thing.
Arnie, I need you to mute.
Well, of course we are, because she's in the point, the double echo.
Mr. Arneson, I need you to mute.
Yeah, we don't hear the echo on
Is this
our
any
end.
better?
It's fine on our end.
It's
Holly.
fine on our end, Holly.
Oh, good, okay. So I'll try again. I mean, really, this derives from the fact that the city has a code of ethics, and the city council has discussed the importance of that code. We had multiple accounts from several different individuals, and complaints were submitted with the city that there is a council member that is alleging that former and current employees of the city are engaged in illegal conduct. Specifically embezzlement, and that is not accurate or truthful information. And so one of the things that that results from that, when you have an elected official saying those types of things, especially when they are untrue, of course, if they are true, that is one thing, but when they are untrue, it creates great vulnerability for the city, instability and unrest. And so the intent here was we had several council members also call our office worried about the implications of statements like that are false statements, what the implications were for the community and the public interest. And so we drafted this ordinance to amend the code of ethics to not only prohibit the disclosure of confidential information from executive sessions, which is already unlawful under your code, but to expand that to ensure that false statements are not disseminated by elected officials or anybody covered by the code of ethics. And so really it's a pretty simple change. It's just that when drafted, the code of ethics did not anticipate false statements. It only anticipated the disclosure of confidential information. So it's just making sure that both types of information are prohibited. And one thing to note, while this makes it unlawful under your code, these types of misstatements are illegal under the law. And so a council member who's making those statements, they may very well be subject to a defamation case that has, damages and involves a civil lawsuit against the council member that's separate and distinct from their role as a council member. But this also ensures that there's no question that the city is not supporting or engaged in that kind of conduct, and that it has its own prohibitions against that conduct. So that's really that's where the ordinance sort of came from. And because of the nature of the comments and the emergent need to deal with it, that's why the administration scheduled a special meeting so council could at least consider this. And then if you choose to enact it, we will be doing that. You'll be doing that at the next meeting.
Good. Thanks, Holly. Peter, did you have any questions?
No.
Tom?
Yeah, so I think what you basically said is that there's liability possibly for a lawsuit, and I'm assuming this could affect any kind of grants that we had in the pipeline. And I don't know, this is probably a question for executive session, but I don't know if we're already in trouble or us not taking action now is going to create a bigger problem.
That's for you, Holly.
Well, no, I would say that this action that you're taking and you're taking it quickly, the city has done nothing wrong. You know, the city council as a body has done nothing wrong. The vast majority of the council members are not out there disseminating confidential or false information, right? But we are getting in front of it, or council is getting in front of it by making it very clear that this is conduct that is not sanctioned by the city council or the city of Whittier. I would not anticipate any impact on any grants or otherwise. That said, when an individual is disseminating false information and that information holds the credibility of coming from any one of you, an elected official of the city who has been engaged in and privy to communications in executive session, you know, it creates unrest, as you might imagine, and it creates vulnerability, because if someone is to believe the statement, false or otherwise, right, like if they believe them, then it might impact the city's business dealings and the way the public sees their elected officials. So there's a lot of damage that can come from doing this, and the council's ability to hold individuals accountable when they do this. I think that's a really important tool for council, or it may be, and of course that's the decision that council will be making.
Peter.
It seems a little premature to discuss this because it seems to be a knee-jerk reaction to something that may or may not have occurred, right? We're not privy to that information yet. And at this stage of the game, it seems like we're closing the barn door after the cows are already out, if the flip side of that is true. So it just seems like a knee-jerk reaction to issues that we have not been presented with yet.
But there's a threat. So
There is. Well, then there are things that need to be discussed when there were
yes,
fewer people in the room.
And this would be just for introduction. This is just you guys talking about whether or not you want to introduce this at your next meeting.
Thank you.
Tom.
So I won't discuss what was told to me, but I was at a community function yesterday for the school, and somebody at the table had brought up, I'm sure, what we're going to be talking about here shortly, and they were generally concerned about it. So this as a preemptive measure, I don't see any harm in it. We can discuss the validity of the rumor.
Sure.
But
We're just
it's
being responsible. Right?
exactly.
Victor, did you have anything? Okay.
Looking at line.
Yeah.
I guess looking at line 91. Unless authorized or required by law to do so, disclose information that the official knows to be confidential or false concerning city business. So at any point saying that this just sounds like that at some point, if authorized, we could disclose false information. I guess that's how I read it. Yeah, we're all authorized to disseminate false information.
Did you hear
Disclose
that,
false
Holly?
Information.
Victor, you
No, I'm sorry. Can you repeat
Oh,
that?
sorry.
It dropped out.
closer.
Oh, sorry. It's like line 91. Unless authorized or required by law to do so, disclose information that the official knows to be confidential, or false. Concerning city business, including but not limited to confidential information disclosed during an executive session. But in there, it just sounds like at some point we could be authorized to disclose false information. And
Yeah, I mean, information will not always be confidential, and it can be authorized. Council can authorize things to be disclosed. But what this does is, and it's a very basic, even if assuming that city council did not have a specific example or a specific reason, and it wasn't a reactive change the ordinance. It still is not, well, what you're preventing is council members from knowingly disseminating false information. So really, even if there is no basis, there's no reason other than you're just updating your code, I don't know that would, it certainly would be a common prohibition, and it's consistent with council's general practice and the law. So I think that's one thing. It's a very simple change to your code of ethics. And the alternative is, we want to allow council members to knowingly disclose, confidential information
No, the
or
second part said
false
confidential or
information.
false.
And that's certainly, that's one way to think about it. And these are discussions. We will have an executive session, and council will, with the public hearing, and have a much more comprehensive discussion on, prior to making your decision whether or not to adopt it. This is really, in order to get it introduced and adopted at the next meeting, that was the purpose of this meeting, is to get that introduction in. So you have to.
Is that it, Victor?
Yeah, it's no, you I understand all that. It was just the second part. It just looked like at some point, someone could totally use that and be like, "Oh, I was authorized to disclose false information." That's why. My concern was.
No, that's a
Lawyers
good.
have jobs.
That's
Yeah,
a
it's
good
like maybe
point.
we could clean that
Yes,
up a little
but-
bit, so someone might not take that literally. And
We can clarify, and we'll clarify, and then that is actually a really good piece to bring an amendment on the floor for council's consideration next time, just to make it clear. I apologize. I now understand what you were saying.
All right, good. Arnie, do you have any questions? Arnie, you're there. You're muted if you are. All right, while you're working on that, Dan, have you got anything?
Yeah, I had at least two questions. One is, this ordinance speaks to prohibited acts. And Holly, would you remind me the consequences? Does that mean that the council member is disbarred or no longer a member of council? What does that statement mean?
Well, there are more than one. So the penalty can be a fine, right, up to $1,000, or it could be a censure. It could be a public reminder to the council member of the violation, an identification of the violation, if a violation is found. And the complaints are kept confidential until they're determined to, and once if a violation is found, then that's when the remedies come into play. So there are several different things that can happen depending upon the severity of the violation, and it really depends on. Now, the other thing is, a lot of times a code of ethics violation, if found, may lead to a petition for recall, right? So it has that potential consequence, but that's not a consequence under the code.
Okay, so what protections do we as council members have from false rumors? As in let's see, I forget what it was that what the claim is what was the claim? Embezzlement. Let's say, embezzlement is something that you can get off the newspaper, and basically anybody in the community can say, Billy Bob's told me this. And so how do we protect people that, given the kind of drama that we've been through recently, I think council's been excellent. I know a lot of people that are plugged into the rumor mill, and we've been very fortunate to have had a very clean execution of some pretty big drama for our community. So for this to burst on the scene like this, how do we factual or verify these claims? Because once a rumor starts, and okay, once it starts, and then so this said, Billy Bob did this, and then we passed this ordinance on the 19th or whatever, and then someone says, "Oh, Billy Bob's still saying this." And it's like, how do we distinguish fact from fiction here? This is
Right. I mean, that's a really great thing about your code of ethics. Your code of ethics uses a confidential complaint process, which means an individual makes a complaint. And if a complaint is filed against an individual under that process, that complaint is maintained as confidential. And the person that the complaint is against has 30 days to respond, and they make a statement, and then a determination is made. So the determination cannot be based on hearsay and isn't, and there's even an initial screening process to really try to ensure that complaints that don't have any basis or aren't grounded in facts or evidence are sort of stopped before they take too many resources. And really, in that case, you're really looking at the initial screening of, even if this person did what is being alleged, is it a violation of the code of ethics, right? So the presumptions go to the validity for the initial screening. So if we take everything as true in the complaint, would we have a violation or not? Is it complete? Do we have a complete filing? If the answer is yes, then it would move forward. The person will have notice and have an opportunity, 30 days to respond. And then the respondent is able to appeal to a hearing officer. And so a hearing officer ultimately determines whether or not they're, in that case, a hearing officer will make the decision. So, or decide whether or not the decision made is.
so basically any
supported
citizen
by the
in the
facts.
community can falsely claim whatever statement they wish, and you could very possibly not have even been around that person, and yet you're guilty unless you can prove your innocence.
So what happens is, nope, you're not guilty unless you can prove your innocence. The complaint process, a complaint will be filed, right? Let's say a person files a complaint. Then that complaint is subject to initial screening. And then what happens is, if we take everything in the complaint as true, would it be a violation of the code of ethics? And if the answer is yes, then that complaint is in essence considered filed. And it's confidential. No one knows that the complaint has been filed at that stage. Then the person the complaint is filed against has 30 days to respond. And then after they respond, a hearing officer determines whether or not a violation has occurred. And there's a hearing which the individual has an opportunity to present their evidence against the allegations and make their statement. And in order to prevail on a complaint, an individual or a complainant has to prove by a preponderance of the evidence that the allegations in the complaint are true. And the hearing officer would make those determinations after balancing and weighing the evidence. And so this process provides a lot of protection for the person that the complaint is filed against, and ensures that any decision made is grounded in evidence. And so one of the other things that is great about the code is it provides for an advisory opinion. So that means if a council member is unsure of what they can and cannot do, or what they can and cannot say, or what the implications might be, they can seek an advisory opinion. And if that opinion says that what they're doing or saying is not a violation, that provides protection and a defense against any complaint. Now, and again, and there's also, there's the hearing, so there's always an opportunity to present arguments against it. But yes, the complaint process does allow an individual to file a complaint against an elected official or appointed official or, the city manager. I mean, this is a process that the city has adopted. And there are many, many communities have these procedures. The confidentiality provisions in Whittier's procedures are pretty strong, and that's to protect against sort of what they would call, a witch hunt or something, similar to that. So there are protections in place to ensure that that is not how your code of ethics is used.
All right, any other questions, Dan?
Nope.
All right.
Yeah, Mr. Mayor.
Oh, yes, Arnie. Yes, now I see you're unmuted. Go ahead.
Well, I've got a question in particular about the hearing officer. Is that a single individual determining that, or is there a party of three, for example?
Committee.
Because a single could dislike the one that the complaint is filed against.
The way that your code is designed is to use hearing officers that are qualified hearing officers. So what that would generally be is a hearing officer from the Office of Administrative Hearings, or a qualified attorney that is outside, not us, not your city attorney. So that ensures that the person making the decision is weighing things much like a judge, if not acting as a magistrate. It's very similar to a magistrate judge, and that you have that objectivity. But also, it ensures that the considerations under the complaint process are going to look a lot like considerations by a court of law. So if there's a violation of a complaint, which might lead to a censure or something of that nature, it's a really good flag of what you would be facing, or an individual would be facing, right, in a court of law, which is going to carry with it much more significant damages in most cases.
Okay, thank you, Holly.
Okay, thanks, Arnie.
Motion for the introduction of ordinance 2023-004, approving this introduction. Wagner,
Yes.
Blair,
No.
Arneson,
Yes.
Shen,
Yes.
Denmark,
Yes.
Mayor Dickinson.
Yes.
The introduction of ordinance 2023-004 is passed and approved, and it will be on your next meeting agenda. Next on the council is council comments on the agenda.
Peter, if you got anything? Victor? Tom? Arnie, have you got anything?
No, I'm good, thank you.
Yeah, Dan?
No.
Okay. Next item is citizens discussion. Those signed in will be given the first opportunity to speak on any subject over which the council has control. Time is limited to 5 minutes per speaker. Anybody signed in? Anybody want to talk? Hearing none. Next item is executive session. Can I get? Yeah, need a motion. And do we need to read the whole statement?
Yes, Mayor, I'll read that in for you. I need a motion to move into executive session. It is attorney advice per Whittier Municipal Code 2.08040C. At the request of the city attorney, meet in executive session to discuss legal matters or receive legal advice from an attorney, including but not limited to matters of pending or anticipated litigation, recommendations regarding proposed city council action having serious legal implications, or other legal matters that the disclosure or the public discussion of which will will or may tend to adversely affect the legal or financial position of the city. All discussions with the city attorney of legal matters considered pursuant to this section shall be confidential. I need a motion.
I'll make that motion.
And
Wagner,
I'll second it.
seconded by Arneson. Do you need to have discussion on this? Mayor, would you like to state who is staying in for the executive session?
Yeah, I'll have yourself, the acting city manager, I believe the harbor master, if he's available, and our city attorney, as well as the council members here.
All right, moving into executive session at 6:35, and then we'll need a couple minutes just to clear the room.
Yeah.
But moving into executive session, Wagner,
Yes.
Arneson,
Yes.
Blair,
Yes.
Denmark,
Yes.
Shen,
Yes.
Mayor Dixon.
Yes.
You are moved into executive session at 6:35. We'll take a brief recess. Session at 7:25 with a motion. So coming out of the executive session at 7:25, motion was made by Arneson, seconded by Mayor Dickinson. All in favor of coming out of executive session and moving into the regular meeting?
Aye.
Aye.
Hearing
Aye.
no, all ayes that you are now in your regular meeting. And I can ask for a motion to adjourn.
So moved.
I'll
Second.
make that motion.
Motion to adjourn by Denmark, seconded by Wagner. If I can get an aye.
Aye.